Welcome, everybody. Welcome to the Advocates. This is Dan Cirucci, and we've got a great show. It's actually going to be very informative, I'm telling you right now, because we are going to talk about two very important things today. Money, money, and the law. Yes, because we have a real expert with us. He's Nick Guiliano. He's the managing partner of the Guiliano Law Group. Nick, how are you?
How are you, Dan? Thanks for having me.
It's great to have you today, Nick. And these are two very important topics. And you're in a very specialized area of the law, Nick. Nick, tell us about it.
We are. Our practice is limited to the litigation of securities matters. We represent investors in cases against brokerage firms and financial institutions for all forms of misconduct, the sale of defective investments, the provision of defective investment advice. We travel all over the country and we represent investors before typically the Financial Industry Regulatory Authority. These are people who are investors that lose their money through stockbrokers.
And Nick, sadly, there's more of this than we might think or might know.
There's a lot of it. Each year in the country, there's probably 8,000 cases that are filed before the Financial Industry Regulatory Authority. It involves all sorts of misconduct, everything from conflicted investment advice, risky investments, Ponzi schemes, open market fraud, fraud for lack of due diligence in connection with the sale of investment products. We also see a lot of Ponzi schemes and actual cases where stockbrokers steal the money from their clients.
It's just mind-boggling. Nick, what is a Ponzi scheme?
Well, a Ponzi scheme by definition is where one group of investors is paid their promised excessive returns generally. And the definition of a Ponzi scheme is that the new investors are needed to pay back the money for the old investors. So the old investors invest money, they expect a rate of return, or they want their money back, but the Ponzi schemant cannot pay them back unless they raise money from new investors. So it's a fiction that just keeps going on and on and on until eventually the house of cards falls and they find that the whole program is a Ponzi scheme.
It's like a never-ending swindle.
It's a never-ending swindle, and across the country there's hundreds of them each year. Last year in New Jersey there was a local attorney that ran a $6.5 million Ponzi scheme. There were two people in Philadelphia recently that were sent to jail for almost 4 years for operating a Ponzi scheme. It's quite prevalent, unfortunately.
And one of the things that astounds me, Nick, is that people who are seemingly intelligent or very experienced fall for this. I mean, how does it happen?
Well, let me say one thing. Our clients come from all walks of life.
Okay.
Over the years, we've represented, doctors, lawyers, judges, celebrities, professional athletes. We've even had an astronaut once. But one thing that those people all have in common is they trusted their broker. Brokers have an air, the financial fiduciaries
Right.
are supposed to be knowledgeable, expert at what they do, and people have a right to rely upon them. They rely upon their superior experience, their background, and unfortunately, sometimes those people run them astray. They run them astray and they put them in the wrong products, or they engage in outright fraud or theft. Sometimes people, we have a saying, if something is too good to be true, it probably is. Mm-hmm. There's no such thing as a free lunch out there, or for that matter, a free dinner. But more importantly...
Right, because a lot of them offer free dinners. Yeah, go ahead.
Well, that's a whole other story. We can talk about that later.
We
but
will,
certainly,
yeah.
People trust their advisors. They trust their lawyers. They trust their doctors. They trust their fiduciaries.
Right.
And unfortunately, sometimes those fiduciaries let people down.
Well, that's my word of the week, and we're going to come to it in a few moments, is fiduciary, Nick. But Nick, speaking of experience and trust and so forth, you have represented as you said, more than 1,000 investors across the United States, several foreign countries, in lawsuits or arbitration claims in federal court, the Financial Industry Regulatory Authority. You've lectured all over the country. You've been on national television. Your educational credentials are absolutely sterling, from Tulane and Temple University Law School. You've been in this you've been doing this kind of work for quite a while. Tell us a little bit about how you came to this, Nick.
Well, I was a securities analyst. I worked on Wall Street as an investment analyst. I was a Series 16 supervisory analyst. I went to law school. When I graduated law school, I worked at firms that practice securities class action litigation, class action antitrust litigation. I guess it was about 27 years ago or so, we started to get clients that had individual claims, smaller claims, people, pension plans, trusts, different smaller claims. They're not the multi-million-dollar claims where I used to work at a national firm. Most of the claims our cases were $200-300 million cases that you read about every day in a Wall Street Journal.
Right.
Our cases are smaller cases, but they involve people. So we really represent just investors.
So that's what, you developed an interest in helping individuals.
We did, early on. The securities laws are the same. Whether you're suing a big company, for securities fraud under Section 10b-5 of the Exchange Act, it's the same set of laws and the same set of legal principles that come to bear when suing Morgan Stanley or Goldman Sachs for breach of fiduciary duty or the sale of unsuitable investments.
It applies across the board.
It generally should apply across the board.
And just because you're dealing with a house or a brokerage firm that has a well-known name, Nick, like a blue chip name, and you mentioned a couple of them, that doesn't necessarily mean you should automatically trust them.
You should never trust anyone. It shouldn't certainly mean that you don't automatically trust them. Most brokers at big firms have conflicts of interest. They have conflicts of interest because the firm is telling them or incentivizing them to sell a particular investment product over another. And you really have to ask yourself, is that broker trying to further my financial goals and interests, or are they trying to further their own financial goals and interests? And unfortunately, you see a lot of that over time. People are certainly better off investing in the Merrill Lynches of this world,
right,
because it's a horrible thing, but we see it all too often in our business, where these lower, smaller capitalized firms do bad things to their customers, and then they go out of business. So there's a lot of unpaid awards out there. Just last year alone, there was an analysis that was put together by an organization that says there's something like $3 billion in unpaid arbitration awards. These are customers that will never be able to recover any money because the broker-dealers that they conducted business with went out of business. They became insolvent. They were closed by regulators.
That is such a sad story. Now, Nick, you were on the inside in Wall Street. You worked there?
I did. I was an analyst. I was an analyst and an operations principal. My background is basically in reading prospectuses, looking at companies. I understand the rules. I had a principal's license, so I understand the mechanics of what goes on on the operational level in firms. For doing this for almost 30 years, I know what goes on in terms of discovery and the kind of documents that are generated and the kind of emails and this kind of due diligence. And what are the firm's responsibilities when it comes to supervising these registered representatives?
So one of the things is you know what to look for.
We like to think we know what to look for. We look for things that are important for people's cases, right? There's going to be issues in every case, and every case is going to be different. But sometimes you'll find a common course of conduct or a common plan among some of these firms where they sell a particular product because that's what the salesmen are told to do. So we'll see a commonality. When you see stockbroker fraud cases or theft cases, there's a commonality. There's little things that we're looking for that make a good case a better case.
So you can begin to see a pattern, but you can see a pattern that other people might not see or find.
Well, I wouldn't really take credit for that. I mean, certainly there's patterns that develop, and the law is pretty well established in this area. And of course, the respondents bar, the people who defend these cases,
right,
all the big law firms in America,
right,
they have a certain method of defending these cases. I mean, in their world, everyone is a sophisticated investor. We have an old saying, you should have known better than to trust us, or that you could afford to lose the money anyway defense. So we see those defenses almost in every case.
This is fascinating. Folks, this is really one of the most fascinating and interesting things, and you're going to learn a lot. Stay with us. This is Dan Cirucci. We're talking to Nick Guiliano of the Guiliano Law Group, and we'll be right back talking about money and the law.
RVN TV is a platform for people of any industry to share their story. Over 285,000 viewers are tuning in to RVN TV shows monthly. We guarantee a great experience that you'll be sharing with everyone you know while increasing your personal and company's brand awareness. But what is your brand? According to Forbes, it's a combination of your logo, your product, your design and feel, and your personality. Did you know that aside from being a guest, we offer even more opportunity to boost your brand? Adding your company logo and website on screen during your interview will allow viewers to recognize your brand instantly. Incorporating images and video clips is another great way to showcase your product during your live segment. Let viewers see how good you really are. And most importantly, there's you and your interview. For less than the cost of a newspaper, direct mail, or a magazine ad, you can leave our studio and within 48 hours have a permanent digital copy of your live segment to link to your social media, embed into your company website, or use in email marketing. Investing in your brand is so very important, and we can't wait to have you.
Welcome back. This is Dan Cirucci, and we're with Nick Guiliano of the Guiliano Law Group, and the word of the week. Nick has already mentioned it. He tipped you off because he's the expert here. He's amazing. The word of the week is fiduciary. Fiduciary. What does it mean, Nick?
Well, a fiduciary is a broad term. It involves certain fiduciary duties. We like to say it involves, thou shalt not lie, cheat, or steal. Those are the basic duties of fiduciary. A fiduciary has a standard of care, a duty to conduct due diligence, a duty to speak fully and honestly and disclose all material risks. But most importantly, a fiduciary has a duty to act in the client's best interest and not in the financial best interest of the firm or the salesperson that's selling a particular investment. To disclose fees, to disclose compensation. I'm selling you this particular product because my compensation is greater than selling another product, which might even be a better product. So fiduciary means that they have their client's interest as the number one interest, and that they refrain from self-dealing, conflicts of interest, and do the right thing.
It's got to be a relationship of trust.
It's based upon a relationship of trust. Fiduciary means trust.
Right.
Lawyers are in a fiduciary capacity. Accountants are in a fiduciary capacity. Your stockbroker ought to act in a fiduciary capacity. And there's this big hoo-ha about the law and are brokers charged with fiduciary capacity, whether it's a matter of state law. New Jersey, for example, is just starting to incorporate the fiduciary duties into a statute. But generally, fiduciaries have a duty to act in the client's best interest. And when they don't, in all 50 states, it's actionable. It's actionable because it's the failure to disclose a material fact. I think this investment is good for you, but I'm going to omit the fact, which is material, that the reason I'm recommending it is because it's best for me. So we see a lot of that.
Nick, before we forget, what's your website? Where can people go if they want?
Well, for further information about common claims against stockbrokers and investment products,
right,
you could visit stockbrokerfraud.com.
Stockbrokerfraud.com.
And there we also have a blog, so we follow all the regulatory actions. You'll see cases that we've handled, and it's a news service. We basically look at developing areas of the law and developing areas within products and certain types of misconduct, and that can all be found at stockbrokerfraud.com. We also have securitiesarbitrations.com, which is rather unique because it talks about the FINRA arbitration process. Most consumers don't realize, but nowadays it's quite prevalent, that when you go to buy a car, a credit card, to do almost anything today, companies will make customers sign arbitration clauses, which means that you just can't go off to court and file a lawsuit if you've been harmed, or even a class action lawsuit if you've been harmed. Instead, your claims are subject to arbitration. Now, arbitration
is under FINRA, what they call FINRA? Or?
Well, this is generally for all consumers. Most consumer contracts have arbitration clauses.
And tell us how arbitration works.
Well, FINRA arbitration is somewhat different. Most people hear arbitration and they think of, arbitration that's non-binding. No. FINRA arbitration, most arbitration, including arbitration before the American Arbitration Association, is very much binding. It's almost virtually unappealable. But it's very much like litigation. So instead of having a judge and a jury, as some people would say, 6 jurors who weren't smart enough to get out of jury duty, you have a panel comprised of 3 arbitrators. Those arbitrators are from a variety of backgrounds. They could be retired judges, lawyers, accountants, professionals, people that undertake specialized training just to be FINRA arbitrators. There's hearings, just like a trial, where you'll find opening statements, the cross-examination of witnesses, the introduction of evidence, closing arguments, and there'll be a decision that's rendered by the arbitrators. As I said earlier, it's virtually unappealable. So it's very much a court-like proceeding. There's all the formalities one would find in court. You'd find a set of a complaint, which you would file in federal court. In arbitration, they would file a statement of claim. There'll be an answer. There'll be discovery requests. There'll be motion practice regarding discovery and generally the non-compliance with discovery. A lot of these firms try to hide documents. They try to keep things secret because they don't want to give you the information you need to prove your case.
And this is precisely why the client needs somebody like you to help them through this process.
That's
aware of the process and it's aware of the whole thing.
That's extremely important. Many times we see cases where, as I said earlier, we represent a lot of lawyers. We represent clients of lawyers as family members. This is a very specialized area of the law, not only with respect to discovery, but what documents to ask for, but when you actually get those documents, what do they mean? In the whole country, there's probably about 150 or 200 lawyers that do this kind of work, and most of us are members of the Public Investors Arbitration Bar Association, which is a bar association of lawyers all across the country that do nothing but FINRA Securities litigation. Sometimes we see cases where a lawyer who's not necessarily too experienced in these matters will take on a case and halfway through the case realize that they've gotten a little bit over their head and seek one of the practitioners in this area of law. And unfortunately, often it's too late because the damage has already been done.
It's too late sometimes when they come to you.
They don't make the right allegations in the complaint. They don't ask for the correct documents in discovery. They don't have the right expert witnesses, which often we use. So sometimes they do a disservice. So certainly clients should always ask themselves, how much experience does this particular lawyer have in these type cases?
This is so important now, folks, because more people are invested in the stock market and invested in securities than probably ever before. I mean, it's really a record number, isn't it, at this point, Nick?
It's a record number in terms of self-traded accounts, self-directed accounts.
Invested as an individual.
As an individual.
Right.
In 1970, they democratized the securities industry, where commissions were deregulated, and the Schwabs and the TD Ameritrades and the E-Trades and all these little companies came on board to offer securities for the average person. That are directed by, self-directed.
Right.
Those are not necessarily going to be cases. The cases that we look at are cases where there's a fiduciary involved, where there's a broker involved. And yes, they're becoming more prevalent because a lot of companies have done away with pension plans. A lot of companies have self-directed 401k plans that are managed by an outside manager. Mm-hmm. So now we're starting to see, and it was for the last 20 years, individuals having their retirement monies invested through a broker-dealer. So yes, there's been a growth in that, where investments have now become democratized, let's call it.
Nick, I've seen commercials on TV, on the radio about, that an investment counselor will take your money Nothing will ever happen to your principal. Your principal will remain safe, and we will generate an income for you for the rest of your life. You won't lose a thing.
Well, I think what you're talking about there, Dan, are index annuities. And we get invitations in the mail all the time to attend a free dinner somewhere, these crash-proof retirement type plans. And what they really are they're selling index option annuities. Now, annuities are only really as good as the creditworthiness of the company that's issuing the annuity. And they'll say, okay, well, you can get the highest value of the stock market, based on the sub-accounts in the annuity over a period of time, or a fixed rate of return. What they don't tell you is that each year they take out 3, 4, 5% of whatever that annuity generates in terms of income just to pay for administrative fees. Sometimes the commissions on those products can be as high as 15%. So if you invest $100,000 in an index annuity, your broker may be realizing a $15,000 commission.
Oh my goodness.
And there's surrender penalties that are associated with them. So you can't sell that annuity without paying a 15% surrender penalty the first year, and it goes down every year after that. So after 15 years, you could sell it without a penalty. But if you want to sell it anywhere along that period of time, you're going to pay a hefty penalty. And you are touching the principal, because what happens when these annuities annuitize, you're trading that pile of cash for a stream of future income, which may last to your 85, or if you died, for your spouse for a particular period of time. But you no longer have access to your principal. Your principal has been traded for these things called guaranteed minimum income benefits.
Oh my
and of
goodness.
Of course, that's good, but however, the fees that are going to be absorbed through expenses and administrative expenses, the issuer risk, because some of these annuity companies might not be around 20 years from now. There's no insurance, right? There's no insurance for the annuity companies. And the best part about it is the people that are selling these products, they're not registered. They're not registered with the Financial Industry Regulatory Authority as stockbrokers. They're not registered with the United States Securities and Exchange Commission as investment advisors. They're mere insurance contracts.
Oh, this is so important to know. Folks, this has been so informative. Nick Guiliano of the Guiliano Law Group. And we've gained so much information here today. Nick, thank you so much. And I'm going to end with a quote by one of our great American patriots and one of our founders, Benjamin Franklin. And remember this, folks. Here's what Benjamin Franklin said. Knowledge always pays the highest interest. This is Dan Cirucci. This is The Advocates. Tune in again next week.